Hi guys, welcome and welcome back to my YouTube channel, your favorite lawyer, Adetunji Progress. Today is not mystery law and makeup. Today we are basically focusing on what the law says. And today we are going to be talking about dissolution of marriage, otherwise known as divorce. How to get a divorce under the Nigerian law, grounds on which you can get a divorce in the court of law. As a lawyer who has studied law in university in Nigeria for 5 years, and I got called to bar recently, I am giving you these tips and saying these things to you as a lawyer. And since I am acquainted with this because I studied family law, I took a family law course while I was in the university, so I know much more about divorce and dissolution of marriage. I must let you know something, that before you can talk about dissolving a marriage or divorce in your marriage, you must make sure that you and your partner are actually legally married. Like, you cannot talk of divorce when you are not legally married. Yes. So if there is no evidence that you guys have been joined together, you guys are married under the law, you cannot go to court to file for a divorce. So you must prove, you must give evidences that yes, that you are married under the law, the Nigerian law this time around. Okay, so talking about getting a divorce, under the Nigerian law, there are various laws that regulate, various acts that regulate marriages. I'm going to be talking about just two. We have the Marriage Act and we have the Matrimonial Causes Act. The Matrimonial Causes Act mainly deals with issues that arise out of a validly conducted marriage. Do you understand? So, as I said earlier, before you can talk about divorcing your partner or getting a divorce in your marriage, you must be legally married. And that is when your marriage can be regulated by the Matrimonial Causes Act. Okay, so according to Section 30 of the Matrimonial Causes Act, what the law says is that if your marriage is just 2 years, is less than 2 years, you cannot get a divorce. This law was put in place to stop people from rushing into marriage then rushing out of it. If your marriage is below 2 years, have that at the back of your mind. You cannot get a divorce. However, there's something about law. When we talk about law, there are always exceptions to every general rule. Yes, that is one thing I've learned when I was a law student in school. There are always exceptions to the general rule. So the general rule is that if your marriage is below 2 years, you cannot get a divorce. But there are exceptions to this rule, and I'm going to be stating the exceptions shortly. For you to be able to file for a divorce, if your marriage is below 2 years, you must get the leave of court to file for divorce. However, there are some things you must put in place. There are some things that must be in place before you can say you want to get a leave of court for you to file for divorce. Now, so for you to get a leave of court, it must be seen that it will amount to exceptional depravity, exceptional hardship, if the court does not grant you leave to file for your divorce. So it must be seen that it will amount to exceptional hardship if the court does not allow you file for a divorce. There must have been willful and persistent refusal to consummate the marriage. There must have been sodomy, bestiality, those grounds, and probably rape, before the court can see that, okay, if we do not give this woman, this man, leave of court to file divorce, even though their marriage is below 2 years, it will lead to exceptional hardship or exceptional depravity. Section 50 of the Matrimonial Causes Act, talking about the 2 years limitation now. If you can prove those things to the court and show the court that, yes, you want to file for a divorce based on these things, those things I've mentioned the other time, you can apply for leave to institute proceedings ex parte. So you can make an application for a leave to institute proceedings. You can make such application ex parte. When I talk about ex parte application, I'm talking about an application that can be done by just one party. Ex parte is usually done with respect to one side. That is, when one party comes to court to file an application for a leave of court. So it can be done ex parte, it can be done by just one person. Moving on to when you are not affected by the 2 year rule, probably your marriage is way above 2 years and you want to file for a divorce, the rule that is guiding that is the Matrimonial Causes Act. That is the act that guides dissolution of marriage. Section 15 subsection 2 of the Matrimonial Causes Act provides for only one ground to file for a divorce under the Nigerian law, and this ground is when your marriage has broken down irretrievably. So if you can show that your marriage has broken down irretrievably under the Nigerian law, section 15 sub 2 of the Matrimonial Causes Act, you can file for a divorce. However, there are grounds under this section 15 sub 2 to show that yes, your marriage has broken down irretrievably. There are things that the court have put in place that if you can prove one or all of these things, one or more of these things, you can show that yes, of the truth, your marriage has broken down irretrievably. The number one thing is willful and persistent refusal to consummate marriage. When we talk about consummation, this has to do between the husband and the wife, that is sexual intercourse. If this is not happening, if your partner after the marriage has persistently refused to consummate the marriage, you can file for a divorce. Is one of the grounds. It is irrelevant if previously, before you got married legally before the law, you guys have consummated your relationship or anything, but once you are married and your partner has refused to consummate the marriage, it is one of the grounds to show that your marriage has broken down irretrievably. So willful and persistent refusal to consummate marriage is a ground. You must actually be careful here, because if you and your partner has at any point in time after the marriage consummated the marriage, you cannot bring your divorce under these grounds. Yes, but once it is shown that after the marriage your partner has refused over time, not because they are sick, not because something happened that it is out of their power, out of their control to consummate the marriage, but if it is persistent refusal, willful one, not to consummate the marriage, it is a ground for you to file for a divorce. Another ground is if your partner has committed adultery and you find it intolerable to live with them. If your partner is involved in adultery and it is so much that you find it like you're no longer comfortable with it anymore, you can no longer live with them. Probably they've been bringing in ladies into the house, your women have been bringing in a man into the house, and you find it intolerable, you cannot take it anymore. So you can file for a divorce under these grounds. If your partner has committed adultery or is committing adultery and you find it intolerable, you cannot take it anymore to live with them. Another ground is, however, if you want to file for a divorce under these grounds, you must be able to prove adultery. Yes, it is not enough for you to come to the court alone and say that your partner has committed adultery. That is why you find it intolerable to continue the marriage. You can no longer live with them. You must actually prove that there has been adultery. Now, what is adultery? Adultery can be defined as a voluntary sexual intercourse with another person other than your partner in a marriage. It is a willful consummation. It is a willful sexual intercourse between your partner and a third party, between your spouse and a third party outside of a marriage. So when you talk about adultery legally, that is what adultery means. So it is not enough for you to say that your partner has committed adultery. You must prove that your partner has committed adultery. And how do you prove this? In proving that your partner has committed adultery, there must be an element of free will. That is, they must have done it because they wanted to. Do you understand? There must be an element of free will in committing adultery. For example, probably you and your wife just got married and your wife was raped. You cannot say she committed adultery if she was raped, because there is no element of free will. So for you to prove that your partner has committed adultery, there must be element of free will. Do you understand me? Yes, so free will is fundamental in proving adultery. For example, in a case before the court, the case of Amburi against Amburi, although it's a foreign case, in that case, the spouse was mentally disordered, was insane, and the other partner wanted to bring an action against him in court for committing adultery. wanted to bring it as a ground to file for divorce. The court held that you cannot say an insane person has his own free will in committing adultery, because there's an element of insanity, and definitely when somebody is insane, most of the things they are doing is not free will. So definitely you cannot say the man freely decided to commit adultery, and you cannot bring it as a ground for divorce since the man was insane. I'm just saying that this is another aspect of the law, that if there's no free will, you cannot prove adultery. Another way is if your partner has behaved in such a way that it is not reasonable for you to live with them anymore. For example, maybe your partner has anger issues, maybe they throw things, maybe he has pointed gun at you before. He has just done some things, or she has just done some things that it has become, intolerable for you to cope with their behavior. It has become intolerable for you to live with them. You can no longer cope with their way of life, with the way they do things. You can bring an action, you can file for divorce under these grounds. And even a reasonable man would not expect you to continue living with that partner. For example, women that are involved in women in abused marriages, where the man will beat you up, you get bruises, you get wounds. You can bring grounds. You can file for divorce under these grounds, because it is no longer reasonable for anyone to expect you to continue living with such a man that treats you like trash. So you can bring and file for divorce under this ground. Another ground is if your partner has deserted you for at least 1 year before bringing your case before the court. If, for example, your partner left home for a whole year, decided to leave you alone, deserted you, you can bring a ground for divorce. Not that probably he went out to work, not that you guys had this mutual understanding before he left. So 1 year desertion immediately preceding, that is, that 1 year must not be maybe 1 year 5 years ago. It must be 1 year immediately preceding you bringing a case to court for divorce. Do you understand? So if you can show that your partner has actually deserted you for a whole year, immediately preceding you filing a court case, then it is a ground for you to file for divorce. Another ground is when you and your partner has lived apart 2 years continuously, immediately preceding you bringing a case before the court for divorce. And probably when you filed for divorce, there is no objection on the part of your partner. You guys have lived apart for nothing less than 2 years, and when you bring a court case, when you file for divorce, he or she, your partner, has decided not to object to it. It is a valid ground for you to file for divorce. Another ground is if your spouse in your marriage has failed to fulfill their conjugal rights as stated under the Matrimonial Causes Act. I'm going to talk about your conjugal right later in one of my videos. Probably it will be another video for that, talking about your conjugal rights. If your partner has failed to fulfill their conjugal obligations and rights under the Matrimonial Causes Act, it is enough grounds for you to file for divorce. Another ground is that if your partner has been so absent that you can reasonably suspect or think that he or she is dead, you can file for divorce. If you can show that you and your partner have lived apart for 3 years continuously, immediately preceding you bringing this case before the court. That is, you and your partner must have lived apart 3 years. 3 years immediately preceding, not 3 years 4 years ago, not 3 years 6 years ago. It must be the last 3 years. For example, we're in 2021. That means you and your partner must have lived apart for 2019, 2020, and probably 2021 too, or 2018, 2019, 2020. That you want to file for divorce in 2021 is fine. It was the 3 years immediately preceding. And sometimes the way the court, the 3 years under the law is quite different. The way the court calculates it is quite different. But then it was the 3 years immediately preceding you bringing a petition before the court. And then last but not the least, I would like to tell you this. There are various ways you bring your matters before the court. But when it comes to marriage matters, you bring them as a petition before the court. So you can bring your action by writ of summons, by originating summon, originating motion, and petition. Those are the 4 ways you can bring any action before the court. But when it comes to matrimonial causes, action under the Matrimonial Causes Act, marriage generally, you bring it by petition. Especially divorce is brought by a petition before the court. So I hope this has really helped you. You can comment below any kind of questions you want me to answer you, and I can answer you personally or make a video to answer those questions. Bye. Don't forget to subscribe to my YouTube channel, turn on your post notification button. I am your family lawyer. Bye.